But first, joining us to discuss, criminal defense attorney, former head prosecutor Bob Bianchi. I think that you've been able to join. We may have had some technical issues. Hi, Bob. Thank you, of course, for joining both of us. Tell me your thoughts. I mean, we were just talking about the fact this is a worldwide story. Everybody knows who this man is. Everybody knows who his music is. And Cassie Ventura, from all accounts, the details she's been giving today, I think, are pretty damaging to him.
It's a worldwide story, and we wonder why maybe prosecutors made it a worldwide prosecution, where typically this would be handled in state court. But, you know, if you push enough and you move things around and manipulate and massage, maybe you can get a federal crime out of it. So what I mean by that, Judge, is that a lot of what's being presented here as a prosecutor, again, I don't have a horse in the race. I don't care. I don't know these people. I'm just looking at it as a former prosecutor. I am concerned that the defense's argument here that because of his stature and because of who he is the reason he's here, because he's being charged with a criminal enterprise. And I would be pointing to all the chairs in the courtroom saying, where's everyone else in this criminal enterprise? Yeah. No, it's an enterprise of one person. And even in their own indictment, I note here it says that he abused, threatened, and coerced to protect his reputation, conceal his conduct, and fulfill his sexual desires. Well, that's not an illegal purpose, even from the indictment itself. And they have to show coercion. This is a 10-year relationship, and coercion is a very specific legal meaning. And this is what we need to educate the audiences about, because people get really, agitated and they use layman's terms for things. Coercion has a specific legal meaning. And this is what the jury will be told. Did the defendant, not how she felt, did the defendant knowingly do these things? Not how she felt, not how it was perceived. That there was threat or serious harm to physically restrain another person in order to entice them to harbor, conceal, provide illegal sex acts. And the defense here is going to say, according to her own words, again, you love it when the prosecution's witnesses can be turned, that she loved him and she wanted to make him happy. And she didn't know that if he'd be upset or he'd be violent or that maybe she would lose her job opportunities or prospects. And I understand all those things. And his conduct, reprehensible as it is, does not necessarily mean it's a federal crime.
And you know, Bob, that's exactly what you were saying, Michael, about where is the criminal enterprise? Where are the co-conspirators? Maybe they're going to bring that up, but we haven't seen it.
And our guest still here with us to discuss criminal defense attorney, former head prosecutor Bob Bianchi. Bob, I want to get your opinion on how the state has been using some of those things we saw in that piece written there by Matt Johnson. Basically, they've been playing them as they change witnesses. Really no commentary, no discussion of them, just playing them for the jury. How do you think that's going over? Do you think that's an effective way or an effective use of that evidence?
So this is really hard to say, Michael. Just anecdotally, I can tell you that when I started my career as a young prosecutor, and then I did defense work, and then I went back to run a prosecutor's office, I found something interesting with my assistant prosecutors, whereas they felt like they wanted to put in every statement that the defendant made reflexively and not tactically, because a lot of times in the statements that a defendant gives, they may be actually interposing their defense. And so by introducing the statement, you may inadvertently, as a prosecutor, introduce the defense. And why is that important? Because at the end of the state's case, the defendant has to make a decision as to whether they're going to take the witness stand. But if a lot of what they have to say about the cases come out in the prosecution's case, then there's not a need, or as much of a need, maybe, to explain that information. And that's why tactically I would tell prosecutors a lot of time, don't introduce. My last murder case, we had a beautiful statement, but it also interposed part of his passion provocation defense. So we didn't introduce it in our direct case, but that forced the defendant to the stand. Then we got to use those statements to cross-examine the defendant as opposed to putting the defense in ahead of time. So we'll have to wait and see tactically whether this was a good move, whether the jury is hearing from her and sympathizing with her, but it will definitely have an impact on whether she takes the witness stand.
Yeah, I agree with that. I don't think she will take the witness stand, but she is outspoken. Perhaps she will decide her decision to do it or not. Let me ask you this, Bob, because today we know unexpectedly the trial didn't happen today. This happens. That's a reality of being a trial lawyer. We don't know the exact reason, but frankly, we don't have to know the exact reason. The court has to make the decision whether or not it should be held for whatever reason was presented to the court. Obviously, today, the judge decided not to proceed. Is that a big deal or not from your perspective?
It's not a big deal, and the judge should always err on the, look, I'm telling this from a prosecutor's perspective, should always err on the side of the defense. I never got reversed once on any conviction I ever had because I didn't argue positions that could potentially be perceived as affecting the client's due process rights. So that's number one. But I think that your audience would find it, like, it's unbelievable to understand a case of this magnitude with the witnesses that are there. You have a team of people that are downstairs trying to coordinate schedules, expert witnesses, flights. It is like a three-ring circus that's going on behind the scenes. So sometimes we see it in the courtroom and it looks like it's a beautifully done dress rehearsal, but it's anarchy downstairs when your detectives and victim witness people are doing what they're doing.
And Bob, I got to ask you, I want to go back to your point about playing of the video. I wonder if her statements to all these various news outlets, reporters, may be putting pressure on her to speak in court. Do you think this jury is saying, wow, you know, she's talking to all these people, why doesn't she talk to us? This is the type of area that I think folks might feel that way. They'll say, man, she's got a lot to say, but she's not saying anything to us. Is the fact that she did all that talking before the trial going to put pressure on her to talk during the trial?
Well, let's see, Michael. Depends whether you're old school or new school, right? So the old school, which I consider myself part of, never wants a defendant on the witness stand. And as a prosecutor, we always knew that the number one way jurors love to convict is from the mouth of the defendant themselves on the witness stand. So, but the newfangled way, people say, and we have these debates all the time as well, the jury needs to hear from the defendant. But we've covered enough cases where we've seen, especially in those police-related cases where they felt the need that they had to get on the witness stand, that their testimony was a disaster and undoubtedly is what led to the conviction in the case. Whereas if the witness or the defendant did not take the stand, maybe there could be one juror that they could create reasonable doubt. Again, to the point, she's already spoken enough and it's being introduced by the prosecution. Is she going to really illuminate a lot more by taking that stand? That's why, as a defense lawyer, the more that her defense gets out through the state's witnesses based on the statement she's made, the less likely I want her on that stand.
You know, it's interesting because now we've been talking about why would her attorney let her make those statements?
Yes.
Maybe he wanted her to speak under controlled circumstances.
Yeah, to get the story out there.
And get the story out there. And I guess the state took the bait.
Yeah, you may be right. Really quickly, Bob, while we have a couple more seconds, do you think Proctor's going to testify for the Commonwealth or not? Are they going to leave him off the stand?
Well, I don't know. I'd say leave him off the stand if you can do it. The credibility assassination. Remember, as a prosecutor, you not only want your evidence to be sufficient, but I used to feel that my integrity and the integrity of my people was most important.
Yeah.
That's a good point, because his integrity's out the window.
No question about it. All right, bring back in criminal defense attorney, former head prosecutor Bob Bianchi to discuss. And Bob, you know, the battle lines have been drawn, it seems, by both sides. It's this rehab concept versus the redemption concept. And quite frankly, I understand Mark Geragos trying to make a distinction because that helps what he's trying to accomplish. But I think both of them involve these brothers acknowledging what they've done. So the question is, where do you stand on what they've done? Was it as a result of abuse or not? Clearly, Nathan Hochman believes that the whole abuse thing is not true. It's an excuse. As long as he sits there, he's never going to buy anything they have to say.
Yeah, great points, Michael. It's a between a rock and a hard place situation. The prosecutor often, and not in just this case, in many cases, and a court for that matter, and we're talking about parole hearings and things that are going on every day with less notorious cases, requires that you show remorse, redemption, and acceptance of responsibility, as they call it. Why? Because they believe that until a person can accept responsibility for their actions, then they can be rehabilitated. But if they're not accepting responsibility, the likelihood of committing a crime when you go out is ratcheted up. But here's the conundrum. What do you do with, in this particular case, additional evidence that comes out that may have been useful in the trial years ago that would support the sexual abuse allegations? Well, in that instance, the defendants can't be remorseful and admit they did something because they would be not guilty of the offense, or at least that would be their argument. And that's where clemency comes in from the governor's office. But from the standpoint of the prosecutor, it's eminently reasonable to say, till they come clean, until they tell us the truth as he sees it, the prosecutor, we're not going to consent to this. Very reasonable.
Very reasonable. Some people feel like it's unreasonable, so I appreciate your explaining that. Let me ask you this, Bob, and that is it surprising to you? It was a little unusual, I thought, that all living relatives of these two boys, now men, are in concurrence. They all want them to be released, and I think there's a lot of forgiveness in their hearts because we don't always see that.
Yeah, first of all, again, I think that's a huge factor. As a prosecutor, I mean, the victim's family's desire, while not compulsory, is extremely relevant to your determination. And the victims' families who were more forgiving, the defendants got better results. There's no question about it. So it is relevant, Judge. But again, if the prosecutors point that, and I know I've been there, I've secured a conviction. I believe the conviction was based upon the law and the evidence in the case. And until they say that they're remorseful, even irrespective of the victim's family, I certainly take that into consideration. I'm not having them released, but I think, again, the victim's family's position on this goes towards the clemency application.
That's a really good point, the distinction between the two. All right, out of time, unfortunately. Thank you, Bob Bianchi, for joining us tonight.